Laduke Akintola, and it's Tope Adebayo LP, not LLP. LP, not LLP. It's now LP. Thank you very much for having me. Okay. Can you see me now? Okay, let me start by saying that our constitution as a nation, which is the 1999 constitution, and what we regard as the ground norm of our law, supreme law, that all other laws must pay obeisance to, the 1999 constitution, is being desecrated by political actors day in, day out, because the system that is supposed to come in aid to assist the constitution from being desecrated, that system also is not enjoying the kind of strength it should enjoy in any democracy. So I'll take time to break this thing down. All of us will be well educated about the anarchy that is being progressively established in our system. So what do I mean? The Constitution clearly provides the number of members that we should have in a House of Assembly, the minimum number of members for a House to have to be properly constituted. The Constitution provides how a person can become a member of a House of Assembly, and how a person can cease to be a member of the Assembly, and now a person who has ceased to be a member of a House of Assembly can be replaced. Our law is exhaustive on all these. Now, let's go to the Rivers State situation. What happened in Rivers State? Rivers State is constituted by 32 lawmakers. That's the Rivers State House of Assembly has 32 members. Out of the 32 members, I think one of them died. Another person left to become maybe an advisor, either advisor or chief of staff to the incumbent governor. Now 30 are left. Out of the 30 that are left, 27 of them defected from the People Democratic Party, being the party that sponsored them to the assembly, that on whose ticket they came to the House of Assembly, to the APC. And by the Constitution, if you defect, you will lose your seat, except you can establish that your defection was actuated by the division in the political party that you left. If you can establish to the satisfaction of the House that you defected from your political party because there is a division, then that defection will be valid. Now, whether or not the defection is valid is one issue that will be determined by what led to the defection. But having defected, we now have 3 members. We now have a 3 members House of Assembly in Rivers State. And the Constitution says that the quorum for a House of Assembly shall be 1/3 of the members of all the House. 1/3 of 32 should be minimum of 10. Now, no. They are left. No, I'll get there. I know the point you are making. Now, the House of Assembly now has 27 defected. Remember I said to you that the defection, another defection amounts to loss of their seats, is a question of fact. It's not something that anybody can sit in his office and determine and have a conclusive determination. Now, but a faction of the House says by that defection, the 27 have lost their seat. The 27 went to court and got an order to declare that they are still validly occupying their positions as members of the House. So by that order, they are members of the House. But the argument of three is that the 27 have lost their seat, and therefore the three will constitute the House of Assembly of the state. That is the quagmire that we have found ourselves in Rivers State today. Now, what are the issues? What are the issues? Number one, there is presently a conflicting judgment of rulings. There's a ruling of a Rivers State High Court restraining the 27 from parading themselves as members of the House of Assembly of the state. That ruling was given in a fundamental rights enforcement procedure rules, a fundamental right enforcement procedure suit filed by the putative speaker of the Fubara faction, asking the court to protect his fundamental right, and in protecting it, he asked the court to declare that the 27 House of Assembly members haven't defected, have lost their seat, and therefore they should be restrained. And that ruling was given ex parte. The High Court gave that ruling without listening to the 27 lawmakers who were representing people that elected them. So by that, millions of river indigenes have been denied opportunity or representation by a judge who abused his power and abused his authority by not listening to the 27 who were alleged to have breached the rights of the person that went to court. And I don't know how the judge came about, came around to giving that order, because a high court of the state does not have the jurisdiction to determine whether or not the term of a member of the House of Assembly has expired. And then there have been authorities in the past, Supreme Court authority, that are forbidding a court from assuming jurisdiction in a matter that it does not have jurisdiction over, especially when that matter is couched in another form. So where we are today is, number one, I don't have access to the reason. I don't know whether the 27 lawmakers have evidence to show that there is a national division in PDP, because PDP happened to be their political party before the defection. And in Abegude and Ondo State House of Assembly and others, the Supreme Court has stated it beyond peradventure that to establish a division in a political party, you must establish that the political party is divided nationally, not locally. So if what they have is a division in Rivers State, then they will lose their seat. The 27 will lose their seat. But if they can show that there is a division at the national level, which may be difficult, with what we have presently, then they will be able to retain their seat. But that's number one issue. The second issue is that, assuming we agree or it's established that there is no division in PDP, and therefore they lose their seat, can the three constitute the House of Assembly of the state? The Constitution says that the House of Assembly shall not have less than 24 members. Clearly written in the law. There must not be less than 24 members. So if you even take 1/3 of 24, you still come to 8. The Constitution cannot contradict itself. The Constitution cannot, require a minimum of 24 and then permit only 3 to take decision to bind the entire state. Don't forget, these 3 people are from just 3 constituencies in Rivers State out of the 32 constituency, and this House of Assembly is meant to make law for the peace, order, and good government of the entire people of Rivers State, not for the constituency of the 3 lawmakers. I hope you get my analysis. So there's going to be another problem there. A House of Assembly cannot be constituted by 3 people falling below the minimum that the Constitution recommend, or the Constitution of the 1999 Constitution as amended recommends. So that issue is there, and it should be. So there's going to be a quagmire. We are likely to run into a situation whereby Rivers State will get to a point where they will not have validly constituted House of Assembly. And where does that lead us? Rivers State may be tottering towards a state of declaration of state of emergency, because governance there seems to be, grinding to a halt. And I believe that these political players and actors there know what they are doing, and they are driving the state towards that kind of precipice. So I don't know whether I've been able to address your question, but presently what we have in Rivers State today, in my judgment, is a political quagmire. It's a serious, and the reason you have conflicting judgment, the reason you have, I keep on telling, because there was one of our clients who is presently in Abuja, one of the politicians, Muslim politicians in Nigeria. A suit was filed against him, and the suit was frivolous, very frivolous suit. And it was, the litigant, the claimant in the matter clearly went to court to blackmail him. You just file a suit, that the case was bound to fail. You file a case, the case is bound to fail, the case is going nowhere, but you just file it because you know that there won't be punishment. Now, they filed a suit against him. We defended him. Of course, they lost at the High Court, they lost at the Court of Appeal, and then the case came to an end. And he asked me, he said, Barrister, what can we do as a country to stop all this frivolity in the name of filing suits or cases against someone who you don't have a valid case against? And I said to him, as long as our law remains the way it is, lawyers will continue to file frivolous cases. Because when they file the frivolous cases, the cost regime, the punishment for filing a suit for losing a case in Nigeria, sometimes they ask you to go and pay 100,000 or 200,000 or 2.5 million. But look at what happened in PLIDE case. By the grace of God, our firm was part of the firm retained by the federal government to defend the federal government in that matter. We defended the suit, and the court in the UK decided that PLIDE was wrong to have defended the application to set aside the arbitral award. And for even daring to defend what was not defendable, a cost of £20 million was awarded against PLIDE. So if you have such in Nigeria, that's why for some of the foreign cases we have, the moment we contact English lawyers, they want to be sure that the cases are cases that can be prosecuted in their courts, because they are running away from having to pay punitive costs. PLIDE has been ordered to pay Nigeria £20 million for daring to defend that suit. So what the system expected is once a suit is filed against you and you know that you don't have any valid defense, just give in. Tell the court that you are guilty. But if you defend it and the court goes through the rigor of having to write judgment, you'll be made to pay all the costs incurred by the other party. Even if the judgment of the court is based on jurisdiction. Let's say the court says, oh, I don't have jurisdiction to handle this matter. At the end of the matter, you will pay, huge cost. But in Nigeria, you'll be surprised by the time the case in Rivers State will be dismissed. The judge may just award maybe 100,000, 200. So the indiscipline will continue. So I told the politician, I said, if you really want to help Nigeria, if you want to restore order and sanity in our system and bring an end to the filing of frivolous cases by lawyers, you need to review the cost regime. You need to ensure that you will pass a law at the National Assembly that will empower judges to impose punitive cost on lawyers for filing frivolous litigation. So now, even though the lawyers to Fubara fashion, even though they knew that the High Court of Rivers State had no bias or jurisdiction to to entertain action relating to whether or not the term of an House of Assembly member has come to an end, they still went to the High Court to obtain an ex parte order. And the court granted the ex parte order. Now, by law itself, ex parte order is meant to last for only 14 days. But you know the tragedy? Even though it is meant to last for 14 days, a recent Court of Appeal judgment said that even when that 14 days expire, it will still remain in effect until a court of law sets it aside. So, on one hand, the rules of court appear to have taken away the tyranny of ex parte order. On the other hand, the Court of Appeal restored that tyranny by saying that a court order remains valid and remains extant until set aside. So we are in all this quagmire in Nigeria, and we need, for us to be able to make progress, we need a leader that understands that weak law, weak judicial system, and weak rule of law impacts negatively on the economy. It discourages investment. Investors are not interested in coming to bringing money to a nation where the law can be trampled upon by hooligans, and they have a court as a sanctuary that they can run to for safety. I don't know whether you get the point I'm making. So this is one of the reasons Nigerian poverty is increasing. People don't know that some of these maladies have ways of impacting our economy. As a commercial lawyer, I understand that investors want judicial predictability. They want to be able to predict whenever any of their commercial transaction result in court. They want a modicum of predictability as to what will happen in court. And then they want a situation whereby their partner will not go and take cover in a court of law because the court is corrupt, not corrupt, because the court system does not have a strong cost regime. So these are some of the issues that I've seen. Number one, as far as Rivers State is concerned today, there is a constitutional logjam in Rivers State today. Number two, Number two, the cases that have been filed and decision reached in those cases were filed by players who understand the weakness of our system, and they're just taking advantage of the weakness. If I have similar issue now that I'm handling in my hand, some of my clients enter into contract with a crook, and the crook is just going everywhere, filing all. He has filed 20-something cases over the same issue, going from one part to the other. And I can bet it with you, nothing will happen at the end of the day. Maximum, they will ask him to go and pay 2 million or maybe 3 million. And the client will have spent a lot of money to defend the case. So as long as you have that kind of system, I don't see where we're going. And I tell people that the members of our judiciary are not actually divorced from the entire Nigerian society. It's a reflection of our society. And the earlier we fix our judiciary and fix the law that empower the judiciary to function, the better. So if there's anything to push, it should be punishment, punitive legal regime against lawyers that file frivolous cases and file the frivolous defenses. There should be punishment. They should be made to pay. I don't know whether you will recall recently, some highly rate testing advocate of Nigeria went to Supreme Court to file a suit asking Supreme Court to reverse itself. Supreme Court imposed cost of 100 million on each of them. With that cost, nobody would try that nonsense again. But that could be done because it was Supreme Court. Because they have said that they are infallible because they are final. And so they can't challenge their decision anywhere. They were imposed. So assuming that happens at all levels of court, I tell you, there will be a lot of decency. A lot of lawyers will be out of work. This is my submission. I don't know whether there are other questions from the audience. I didn't get your second question is if I get it right, is that if that the
second question is the matter of costs. You know, it's a matter of costs. You mentioned punitive costs in order to serve as a deterrent against
yeah.
those who file frivolous cases. And I'm like, what if on the flip side, you have people now who are now afraid to even file cases because they know they're going up, for example, against a Tope Adebayo who can afford the top lawyers in Nigeria, who can afford to drag it out, and then even if the case fails, Tope can afford to pay the fee. But this poor man on the streets who needs justice, but is afraid because of punitive costs, and because of that, this poor man runs away from filing cases for the court to protect their fundamental rights. So that's the second one. It's just a flip. Just
The first what the first one again?
First one was about the first one was about that appeals court thing, where the appeal court, you said they've revalidated the interim injunctions to give it perpetuity, more or less, until set aside. And I'm like, do we know how
Okay.
lawyers?
Okay.
You know, Ganifa when me used to do,
Okay.
you can go on, yeah.
No. Okay. Let me start from that appeal. The decision of the Court of Appeal of Lagos State is not in the Fubara's case, please. Are you there? The decision of the Court of Appeal, the decision of the Court of Appeal was not given in the Fubara's case. The decision of the Court of Appeal was given in another case entirely. So in that case, an ex parte order was procured against, if Olanipekun was the appellant in that case. So it was an ex parte order was procured against Olanipekun's clients in that matter. And Olanipekun waited for 14 days and went to court to say, hey, this order has expired. And the court said, until a court of law pronounces that even though that 14 days has lapsed, but until a court of law pronounces that the 14 days has lapsed, another court is still another court. So he went to Court of Appeal in respect of the matter. And the Court of Appeal agreed with the other side against Olanipekun. And the Court of Appeal said, it's travesty. I'm telling you, he said, it's like bringing us back to where we were before that rules. So if you procure today, if you procure an ex parte order, the position of the law is that until a court of law or that court especially says that order has spent, you cannot sit in your room or your law office and pronounce it's spent. So it's not in the Farah's case. I'm just talking about the precedent. Now, in respect of the what do you call it? Cost that I propose that we should push. I need to make a clarification, and I believe you will know this, that the fact that a lawyer is a senior advocate does not make him better than other lawyers out there. Law, if I read provision of Section 1 of the Constitution, what it says in my office is what that Section 1 says in Afebabola's office. The law that the senior advocate apply are not different from the laws that other lawyers apply. And so I have stood against many of them in the past and defeated them in courts. So that what determines whether or not it's an advocate or an advocate is good is not the SAN or no SAN behind his name. That's number one. I agree with you that there are lawyers, both senior and junior, that are very bad, that can mess up clients' cases. There are lawyers that can mess up client cases. And so, but that is not an excuse it's not sufficient. You know, if, for example, you're a litigant and you go to this lawyer, you have history of this, you look at the record of a particular lawyer and you know that he's always coming back, you know, with huge costs against his client, he will go out of business. So that cannot be an excuse for us not to do what is right. Allowing people to file frivolous cases and frivolous defenses is drawing us back as a nation. And the fact that a lawyer does not have a beautiful office does not mean it's not good. As in law, there are public interest lawyers who are more brilliant than those in beautiful offices on the island. So all I'm advocating is, once you know as a lawyer that filing frivolous cases attract severe consequences, you will interrogate the fact presented by your client more deeply. You will think twice before going to file a suit. Let me give you one of the challenges that Nigeria went through, one of the things that we went through in law. There was a case that was instituted, Tuko and government of Gogola State. It later became Tuko and government of Taraba State. That case lasted for like 20 years. It went from High Court to Court of Appeal to Supreme Court, came back to High Court to Court of Appeal to Supreme Court. Twice. And what happened? The suit relates to Obaship Tosu, Emirship Tosu. A lawyer went to court to go and file, to go and characterize it as a fundamental right case. And the court said, it is not what to call this case that I will give to it. I will look at the fact to determine whether or not it's a fundamental right case or it's a substantial affairs case. And the court ruled that, hey, this is a chieftaincy matter. It's not a fundamental right case. Do you know that over that thing, over what I just said, that this thing lasted about 10 years? So we can't continue. How many months did you spend on P&ID? I think we spent about a year. 20 million pounds. That was what they asked them to go and pay. And these are people that had already procured judgment against Nigeria. They've been able to procure a 9.6 million pounds judgment award, arbitral award against Nigeria. And that award had been, confirmed by a high court in England. So they were the point of enforcement when we went to court to say, this agreement, which happened to be the foundation of the award, was procured by bribery and corruption. And we work on that matter and satisfied English court that the agreement that was foundational to the judgment was fraudulently procured. Now, the other party defended it for daring to defend it, even though they knew the defense. They were asked to pay 20 million pounds. What does that say? What does that signal? That signals to other lawyers in Britain, in the United Kingdom, that no matter the amount of money that your client promised to pay a fee, if you know the defense that your client will be pushing forward will not be sound, don't go. Before we could convince the Queen's Counsel, who handled the Nigerian case, to represent Nigeria, my brother, it took a lot. It will make us, you see, it's just, I look at people. If a foundation is destroyed, there's nothing the righteous can do. If we don't do what we need to do to repair the foundation of Nigeria, to expect a prosperous nation, without addressing the small issues, we are deceiving ourselves. We are. Prosperity does not just happen. I mean, enduring prosperity. That's why you see, foreigner will make money grow. After some time, they will crash. Because there is nothing to fund, there's no foundation to sustain the edifice built. So the edifice that we call Nigeria, if you don't go to repair the foundation, and one of the foundation is this thing. Okay, look at what happened in Kano State. Look at other counter-order federal government. No nation survives that way. It's a theater, it's charity. So because I believe one of the function of PLIDE is to constructively come up with ideas that can be deployed to build Nigeria. And I'm saying, as a lawyer who have practiced for like 20 years now, I know that foundational to our prosperity and growth and development as a nation system. Tope Adebayo said, the legislature that is that if they have respect for an order, will survive the shortcoming of the two other branches of government. Their respect for the law and order will vanish with it to the great detriment of the society. That's what we are having in Nigeria. But the respect that so Tope Adebayo, that's the name of the man, he said that it is in the judiciary and not in the legislature that the citizens feel the keen cutting edge of the law. He said, if they have respect for the work of the court, their respect for law and order will survive the shortcomings of the two other branches of government. But if they lose respect for the work of the court, their respect for law and order will vanish with it to the grave detriment of the society. The reason you are having all these groups springing up in the this Kenekon here and the other sort of military group, it resulted from the judiciary that has not been repaired, the foundation of the judiciary that has not been repaired. Injustice plays on our streets. They will just tell you, go to court. We've done, okay, this issue. And another thing is that politicians will always insert provision to use as escape route. Now, if the law has simply said, if you defect, either your party is divided or it's not divided, or if you defect, you lose your seat. We won't be in this quagmire. Or if the constitution has gone ahead to say a proclamation by INEC that a party is divided will be conclusive proof of division, there won't be all these arguments. But such thing is not provided for. Therefore, if a House of Assembly member alleges that there is a division in his party, and because of that, he is defecting, nobody can declare his position vacant until a court says is right or wrong. So we just put ourselves in such quagmire that only leaders who understand the effects of all these maladies on the people will be able to, actually, build a prosperous and enduring Nigeria. For example, because of what is happening now in the Southeast and even River State, it will be very difficult for me to go and do any business there. I don't know about you. So both Wike and Fubara obviously do not care what happened to the poor people. And if businesses are not brought to your state, your people are being impoverished. Because it's like blocking the access point of fund into the economy. So my answers to the two: number one, I've said that the Court of Appeal case is not, the Court of Appeal decision is not in the Wike Fubara matter, but another matter. But the decision of the Court of Appeal is a binding authority with respect to the effect of a spent ex parte order. If an ex parte order is spent, it will still remain effective until a court of law sets it aside expressly. That's number one point. The second point on the cost regime is that I do not believe that the effect it will have, on people who may be afraid that they don't have a good case is sufficient, to throw away the need to have a strong cost regime. Thank you.
Yes, thank you so much, Mr. Convener, and sincere thanks also to Barrister for those legal insights as part the issue currently going on in River State. But my question is also like a perspective to one of the presentations and the comment made by Barrister. In as much that the Constitution stipulated a minimum number required for the assembly to properly function. And now that these assembly members have, done something that a law in River State have seen as if they've gone against the law, they were currently suspended. Can we now say, that the law in this case now will not have to, like you said, the law cannot contradict itself. Can we say because we want law to have a say, people will now do something wrong? Because we don't want law to, contradict itself, there's a minimum number of honorable members required for a quorum to be met, and because of that, can that decision be reversed? One. Two, and in this case too, if eventually they were not able to substantiate chaos, anarchy, or division within the party, which was responsible for this movement, Is it that they are going to automatically lose their seat? And if they do, will a rerun election have to be held, for their constituency not to properly and effectively lose out, in the representation at the House of Assembly? And again, in this case now, because I know we also had precedents in this country where honorable members defected, and because of that, they automatically lost their seat. And like you said, we're beginning to see contradictions. We are beginning to see that the law is not properly in place. It's not directly addressing this issue in such a way that if you defected under any ground, you are expected to lose your seat on a point of morality, on a point of not being a political prostitute and all of that. So that is just my view, and I want you to shed more light on that. Thank you.
Yeah, good evening, the convener. Our dear Egbon, Barrister Tope Adebayo. Thank you. No, no, we are in the midst, we are, we are still, yeah, I think, yes, sir. The Barrister Tope made some points that struck my heart, and there are questions that I decided to write down, to write here, to pen here, just for the sake of, him answering them. One is that he posited that by law, in the higher of the law, that there has to be at least 24 or 25 members, to make an assembly. Now, if eventually the case in Rivers, gets, established in the appeal, and the members from the PDP members that have defected or that have left the party, eventually have to leave that seat. Does it mean that between the time and the time a new election will be conducted, in the high of the law, there is no House of Assembly in Rivers State? One. Two, does it mean that in the high of the law, anything, any law, any bill done or passed by that House of Assembly by the three members are not within the ambit of the law and so cannot be taken or worked on? What also happens? So if the governor of the state decides to push anything, whether supplementary budget or anything, to that House of Assembly, to the three members, because it has become a custom in Nigeria. And I wonder, immediately by Tope raised that, I wonder that what our lawyers doing, what have they been doing? Because we have had instances where, out of, we had a series of it in Ekiti, for instance, where out of 24 members of the House of Assembly, you will just have that 15 are left, and then 7 of them, or maybe, are the ones that the governor, will be presenting the budget of the state. Then how can legality take its source from illegality? So I am asking that what happens to everything that has been done, everything that will be done by the three members of the House of Assembly? And is there still House of Assembly in the high of the law? Do we have members there in Rivers State? Thank you, sir.
Okay, yes. So let me quickly run through the answers to the question. Let me start from the because the questions are related. Fahmi is asking the implications of loss of seats by the 27 members of the House of Assembly. As it were now, there is a court order validating their membership of the House of Assembly. And so with that order validating their membership, they've not lost their seat. But assuming that a court of law pronounces that they've lost their seat validly, then a rerun election will have to be conducted. There cannot be a valid sitting of the House until the rerun election is conducted and the House of Assembly of the state is properly constituted. Three member representing only 3 constituencies out of 32 cannot constitute a House of Assembly within the contemplation of our Constitution. What they are and then to Okunuga's question, every actions taken by those 3 members are invalid, null and void, unconstitutional, and anytime, any day is going to be invalid. It's has been invalidated already by the court, but if you take it to Supreme Court, write it down today, it will be invalidated. No court of law. Because you see, apart from what people forget when they are making this argument is that in interpreting the Constitution, you have to understand the intendment of the drafters. The intendment of the drafter of the Constitution is to ensure that this set of people representing the generality of the people in the state are truly representative of the people that are in the state. Whenever they are making any decision, they are buying the state. We are not in the military government, in the military era, where few people will just sit down in the Supreme Military Council and take decision to bind the entire nation. It's democracy. Don't forget. Democracy is run through elected representative of the people. It will amount to disenfranchising more than 70 or 80% of variance. If you allow those 3 people to take decisions that will bind, don't forget, bills passed by them will be said to be a bill passed by entire River State. So forget even let's even come to the court of common sense. Common sense. House of Assembly members, if you look at the Constitution says that the number must not be less than 3 times the number of representatives elected by the state into the House of Representatives. So that means that they want those that will go to have more reach, further reach to the grassroots. They want them to reach more number of people than the House of Rep members will reach. So what is at the back of the mind of the drafter is they must representative. So for anybody to come with a fraudulent argument that 3 is sufficient, it can't stand. It cannot. It cannot stand. It will be defeating the intendment of the Constitution. So everything done by these 3 people is a question of time. It will be invalidated. So we are running a government of brigandage. See, people know, they know, Fubara knows. If they agree, assuming it is even agreed that, okay, these 27 are defected, they lost their seat. The next thing to do is for INEC to conduct a rerun election. And there cannot be a valid sitting of the House of Assembly, because what the law says is that if the Assembly does not form a quorum, they must adjourn. They must adjourn indefinitely. So if you are pushing the argument that 1/3 or is 1/3 of 3, that means one can sit. It doesn't make sense. So, and lawyers are not senseless people. Judges are not senseless people. You know, they cannot, there will never be that day in Nigeria that 3 will constitute 10, it will constitute 1/3 of 32. That day will not come in Nigeria. Chike Obi will never be able to do that math. And that's why the constitution says, once their quorum is not formed, adjourn. Adjourn. So I don't know whether I've been able to answer all the questions. You are muted.
Yes, sir. Yes, sir. You have answered the question. Yes, thank you, sir.
All right. Hold on. All right. Hello. Good evening. Good evening, sir. Good evening, everybody. Yeah. Yes, my question have been answered, but what I wanted to ask was, which was part of my question also, is that can the governor, let's say for example, the 27 lawmakers lose their seats, and the governor is left with that 3 lawmakers. Okay, constitutionally, they cannot form a quorum. But can the governor continue his own constitutional job without the State House of Assembly? Is it possible for the governor to rule a state without the State of Assembly? That's my question.
Good evening. Good evening, Barrister Tope. Please, I just want to ask a question, just to derail a little bit. I think there was a similarity of this kind of issue in Edo State during the first tenure of this present governor. And now it's like there is a kind of similarity. And during that tenure, or during that first regime, I could remember there was no assembly members in Edo State. And now we are having the kind of similarity again now in Rivers State. And compared to what you said, that if this thing passes, there are procedures and which leads to state of emergency. Now my question is that what was the step taken then in Edo State? Because the first tenure, the governor ran the state without the assembly members. So linking it to the question of Ayole now, can the state run without the assembly? That's my question, sir.
Good evening, convener. Good evening, everybody. My question is very simple. Is that what is yes, when you come back, you can summarize for him so that we'll not be taking time. My question is that what is even the procedure for defection? Because now last week now we are even hearing from the news that even some the House of Assembly said I will claim it they have not defected, that they are procedure. So in the eye of the law, what is even the real procedure for defection? And who has the power to pronounce a seat vacant? Is it the speaker or who? Is, and secondly, is that what my observation is that these people are always using the states to play politics, because last month there was a defection from PDP to Labour Party in Abia and nothing happens. So it's when it affects these people, they come to NAS and start making noise. These are my contributions.
Yes, yes. My question is it possible for a governor to perform his constitutional job without the House of Assembly? In a case where the governor is left with 3 assembly members and the law does not permit them to because they didn't form a quorum. So is it possible for him to continue his job without the assembly in place?
Okay. Hello. Yes, my question is that there was a similarity of this kind of scenario in Edo State during the first tenure of the present day governor. And what was the procedure of the law? Because I could remember there was no assembly members in the first tenure, and it was because he was having issues on party issues. He's a PDP man, and the House of Assembly, they are APC, and they were not ready to have a stand together. Now, what is the position of the law? Because the similarity is about happening again in Rivers State. What is the position of the law on this? Relating to Ayole's question that can the governor run the state with or without the assembly members? Thank you.
Yeah, my questions. Good evening, sir. My question is that what is the procedure for defection in the eyes of the law? That, like, some weeks ago we heard in the news that even some assembly member are claiming they have not defected, and the follow up was that in an Abia, like, some PDP member defected to Labour Party officers and nobody make noise about it. What is the procedure of the law? Should there be a pronouncement from a speaker, or as in what is the procedure in the face of the law? Thank you, sir.
Now I got the first two. Hello. Hello. Yeah, the
Sir,
internet here is
maybe you should
unstable. I
answer
don't know
the
why
two
it's
first.
suddenly behaving abnormally. Are you there? Yes. Can you hear me now? Yes, yes. Let me put up the video, maybe to help. I think it's better they ask their question so that because I have little time, so let them ask their question because it may be all these questions are interrelated. Are you there? They are all interrelated, so that we can.
Okay, can you hear me? Good evening. Okay, so I just wanted to ask a very straightforward question. Based on all these issues coming up, I'm wondering, doesn't this highlight the fact that our government system is currently just bogus? Because the state is still running. No one is telling the state it can't run. You get my point. So, like, okay, now the house is literally not existing and the state is still running. Does this not point to the fact that there are alternative ways to run these states without this very overpopulated form of government that we currently have? Just a thought.
Thank you. Thank you. So let me quickly run through the questions, and I believe what I will say will address all the questions. First and foremost, when it becomes Nigeria is a theater of there's a lot of joke happening, all in the name of politics in this country. Someone made reference to the Edo State situation. When that happened, the Constitution was to kick in when it was impossible for the House of Assembly of Edo State to perform its constitutional duty. Section 11 of the Constitution required that the National Assembly would take over the function of the House of Assembly of the state when it becomes impossible. But our court system still became a clog in the wheel. Our politicians just went to court and filed a suit to restrain National Assembly. It's just a huge joke happening in Nigeria, I'm telling you. And that's why I said, until we fix the root of the problem, which is the cause, every man invested with power is bound to abuse it and to take it as far as it could go. Yoruba people will say, Agbara ojo ko lohun onile wo, onile ni oni gba. Anybody would want to take advantage of you if you don't do enough to protect yourself. And who needs protection here? The judiciary. Because when it was impossible for the House of Assembly of Edo State to perform its function, the politician understood that National Assembly will have to step in under Section 11 of the Constitution to begin to run the assembly, to do what the assembly would have done. They went to court to go and get an order to restrain them. And the absurd continued. The theater of the absurd continued. So, but in this case, so that's what normally, so if you ask me what should happen if it becomes impossible for them to perform, National Assembly will take over. But the question today is the 27 members, even though they defected, by reason of the judicial imprimatur, put on their membership, they are still members of the River State of Assembly by the judgment of court today. And so every proceedings of those 3 men is dead on arrival. But if tomorrow, maybe this case obviously may get to Supreme Court, if the court really wants to redeem itself, if the CJ, I will call the president of the Court of Appeal, the moment this matter gets to you, list it straight to the Supreme Court, send it to us, so that we can put all these things to rest. Yes, they will just state it to Supreme Court straight. The case stated. They will state it to Supreme Court straight and say, please, this matter has been taken to Supreme Court, let them decide. So that nobody is wasting the time of the. You see, we don't have many patriots in this country. If we have patriots, all this jagba that we're having, I tell you, the judges would have called a meeting to say this politician wants to abuse the hallowed chamber of justice. We must not allow it. Send this thing to us on time. They will have called the NBA to say, please, call your people, your lawyers to order. But we turn everything, every hallowed thing, we turn it to joke in the country. So, back to the question, if there's a decision on the status of the 27 lawmakers, let's say the court says finally, the court says these people are maybe let's say the court says that 27 members who defected rightly. then that means they will go back and continue to run the House. But let's say the court said they were wrong to have defected and declared their position vacant. Then immediately the INEC will conduct another election. A by-election is by-election in those constituency. And that can happen within 30 days or thereabout. And any decision that requires the approval of the state out of House of Assembly by the governor. If the governor cannot, if the constitution says a governor cannot take a decision without a House of Assembly, the governor definitely cannot take that decision, except he gets the House of Representatives to take over the function of the House and take that decision for him. He cannot take it unilaterally. He cannot. It will be constitutional breach. And if he breaches the constitution, you ask what consequences? Well, it's a grant for impeachment. The question is, who is going to impeach him? National Assembly can take over. But that is if they don't go to court again to go and file a suit against the National Assembly. And they will always get a judge that will just, God will help us in Nigeria. God will help us. It's almost, it's tough, but it's not insurmountable. You know, insurmountable. Any other? I think I've addressed all the questions.
I
Yes.
think I've done.
Uh,
Are you talking to me?
Yes? No, 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 no. What I was saying earlier, what I was saying earlier was the fact that given what is going on in Cross River now, the house is literally not existing and the state is still functioning. Does this not also point to the fact that we just have an overpopulated governing system? If there is a system, you know, this kind of issues, there needs to be, I don't know how to put it. If it is possible to unseat the house for a tenure and the government is still running, is not considered non-functioning or incomplete or whatever, shouldn't we look at it as a challenge to the fact that we're just creating positions to place people without necessarily looking at their relevance? I hear the person saying legislation and executive, their functions are different. But at the end of the day, this house is literally not existing and the state is still operating. So I'm just, you know, that's why I said it's not a question, it's just a thought. Like, okay, so if the state is actually running like this, then is it possible that we have a system where instead of having all these arms that seem to not be relevant, you know, they just all seem to create bottlenecks at the end of the day? Is there a way that it could then, okay, since you don't want to exist, you are turning this to a party thing, can we just eliminate? Is it possible to just have a provision for this kind of situation? Because now the behavior of this particular house is a burden on the state because of the constitution. So what if the constitution addresses in a way that, okay, in this situation, negate them and let the state continue, let there be a backup plan for the state to run? They are all playing parts also with the rights of the people at the end of the day.
Thank you. So let me quickly run through. First and foremost, I do not know what played in the mind of the court. I did not. I'm not conversant with the facts presented to the court that led the court to restrain the National Assembly from taking over the proceedings of the Edo State House of Assembly in 2019. But if you check online, you will see that the National Assembly actually condemned the ruling of the court because they felt that it was a breach of the separation of power. It's a political question that should not have been entertained by the judiciary because issues like that normally the judiciary is supposed not to entertain it, you know, to stop the state from doing what the state should have, the state of House of Assembly from doing what it was constitutionally empowered. To stop the National Assembly, the House of Representatives, from doing what is constitutionally empowered to do. I believe it was wrong for the court to have given the ruling, but the law is that an order of the court, no matter how poorly, no matter the intent behind it, is binding until set aside. So if the order is bad, a bad judgment or bad order of court is still an order of court and must be respected until set aside. That's the law. And, you know, for there to be a good society, we have to take it the way it is. And I think that's the question. So I don't know what played in their mind. I don't know why the court granted the order, but I believe it was wrongly, you know, granted. And I expected the National Assembly to petition the NJC, you know, at least for the NJC to discipline the judge that gave the order, to serve as deterrent to order. I don't know whether that was done, but that's just the much I know about that. And then the last question, I'm trying to remember, somebody was trying to ask, I can't remember, I can't recall the last question. A comment. Mm-hmm.
Yes, thank you so much, Mr. Convener. Yes, on behalf of PLIDE, on behalf of the leadership and members of Platform for Liberty and Democracy, we sincerely want to appreciate and thank our brother and a barrister, Tope Adebayo, for those legal insights, for how well he was able to propel, you know, opinions, and most especially the right thing that should have been done. And I could remember in one of his observations too, there is need for a constitution, you know, to be working and address the fundamentals rather than, I don't want to say ambiguity because it's a legal person, so they always don't want us to say the Constitution is ambiguous. Yeah, but nevertheless, we sincerely want to appreciate you and we thank you very so much for coming, and we always want to have you back again on this platform. Thank you and God bless you, sir.
Well, thank you very much for having me. We'll continue to work for, do what is right, to make our contribution towards the emancipation of Nigeria. Nigeria is a country with a lot of potential, but some of the issues that we have been discussing that will be responsible for our retardation as a nation. And I believe that by the grace of God, one day, a leader that will truly love us will arise, and Nigeria will breathe a sigh of relief. Thank you. Good night.
Thank you very much, Mr. Convener. Yes, for the job well done and how well you've been able to coordinate the affairs of this program since 6 p.m. But however, yes, my own, I just want the leaders here to let us discuss the genesis of Rivers crisis from different perspectives. And I remember the convener asking the other time that most people who sometimes appear very calm, very gentle, eventually do turn out to be rebellious. And those who appear to be outspoken, who you feel they might not be loyal or submissive to considered authority, turn out to be very loyal. So as it is, what do we think has been the genesis of this issue? Was it that they were just two bad boys who, because of politics or because of some certain ulterior motive, binded them together? And eventually, you know, when things fell apart, they had to go in different directions because of, can we say, peculiar interest? Can we say selfish interest? So I just feel if our leaders, anybody having opinions about the genesis of Rivers crisis.
Yeah,
and,
I was it last week? I was having a conversation with someone. The man is from Rivers State, and he was telling me that his own defense was against Wike, and what he said was that out of the that Fuba do not appoint a single commissioner by himself in Rivers State. That was the first issue they have. And I now asked him one question. My own question was that, does it mean Fubara is not aware that most of these godfathers in Nigeria today, for them to make you a successor, you won't have access to appoint a commissioner because they will be the one to dictate the tune to you. So I now ask the man that who is at fault between Wike, who betray one and the other between Wike and Fubara. So let me throw it to the house.
Yes, please, guys. Who betrayed? Who actually? But at the same time, I feel it might be difficult to answer that question because we are not really party to the agreement they both had. Because when the going were also good, They had it well. And I remember the convener also saying it, which was also in the public perspective, when there was an issue with Fubara, with TFCC. It was this same Wike, while he was the governor, that shielded Fubara from persecution and arrest. And now that, you know, the yam pepper is now being scattered now, who should we say betrayed who in this case? Can we say Wike wanted to, you know, being necessarily having overbearing influence on Fubara, and the influence eventually, you know, backfired? And can we also say that Fubara happened to exhibit egocentric moves, and Itato turned out to be an ingrate who is paying the hand who fed him, you know, in a bad light? So can we just quickly have discussions in this direction for the next 10 minutes? Any leaders who want to share an insight regarding this? Tolu, are you there?
To me, I don't think Fuba was that loyal to Wike in the first place. To me, or that's to my own opinion, because to me it was too early. It was too early for them to start having issues. It was too early, not even up to a year. So his loyalty when Wike was governor, to me, is not 100%. Because in Nigeria politics today, I always tell people, once you become godfather choice, then you must be ready to play and dance to their tune, except if you are not desperate. If you are not desperate to hold a particular position. That is Nigeria politics today. So you must stand for whom you are.
Again, because if you are also familiar, you know, with the relationship, the working relationship between Fubara and Wike, it was his accountant general. And many of us understand the sensitivity of being an accountant general of a state, and the role he might also have played at one point or the other in the management of the state's treasury. Could we have said that Wike would have appointed somebody not loyal to him as the accountant general of the state?
Can we compare this with the Ambode scenario in Lagos?
Absolutely.
When you talk about the accountant general and the governor, you see the
similar
similarity
now.
there.
It's
The
similar.
similarity there.
It's similar, yes.
Exactly.
It's similar. Let's compare
Exactly.
it.
So
Yes.
there's already a precedence to this issue of accountant general and their primaries. So let's just say there seems to be a trend between accountant generals and their primaries, which is consistent with the Wike and the Fubara drama.
So we can say that the past accountant general who eventually might become governors do have issues with their, we don't want to say godfather this time around, who always put them at the interest and the aims of affairs of the state. But however, one thing I also feel, in my own personal opinion, is there is a limit to what an average Nigerian politician can take. You know, I also feel that at a time, this relationship was completely harmonious. You know, they had a very proper handshake, and because Wike too, to us, and we feel Wike is always a very smart man, to a large extent, or their stance, the local politics, and it might have also have sampled opinion of the people even within and outside his cabinet for him to have resolved in picking Fubara as the governorship candidate for PDP in Rivers State. It's just as if things turned out the other way around. And again, if he wasn't loyal, he wouldn't have accepted Wike to have, you know, dominated over 80% of his commissioner even to his appointees, which we later saw many of them falling out when the crisis between Wike and Fubara, got escalated. So for me too, for him to have accepted most of those things, which in many other states too, it wasn't like that. We had states in the southwestern states where the governors were previously in the position or appointees of the former governors, and most of the commissioners were not appointed by the ex-governor, who left the corridor of power. So for Wike, for Fubara to have allowed over 80% of his cabinet to have been formed by Wike, it's also a signal to a level of being loyal to Wike. But it's just because from other people, we got some opinions from River State also confirming that Wike at certain time was, overstretching the issue, was overstretching his boundary, and was also wanted to, put the governor under his palm and his arms. And so there are so many other contradictions. Convener, you are raising up your hand, sir. Yes, please, let's share your opinion.
Exactly.
Fubara is also a smart politician because he wouldn't have started fighting
That's
Wike
why.
when he had his determination, his case still pending in the court. And when he knew that he got the total authority as the governor. At that time too, he also wanted to exhibit his power as a governor to let Wike know so that, now you're a minister in Abuja, I'm managing the affairs of the state, and I should be able to exercise my authority to a certain extent. And we should also not forget that fact. That is a typical attitude of not even a politician, of an average human being who might want something from you, or who still perceive that, okay, there's an atom of a favor I can get from this individual, might tend to be loyal to you. And after that, too, when they are now beginning to be overstretched, there is tendency for an average person to want to counter-react. And for me, I felt that was actually what happened. Because forgetting that fact, if Wike is to come out in the open and can say authoritatively, he has so many things to say about Fubara. Fubara might have committed so many other things into the hands of Wike, and likewise Wike into the hand of Fubara. It's just a politicization and a friendship formed on the basis of interest. And at the same time, now that the interest has fallen out of place, well, interest is also very permanent, but as we have it right now, it is just an exercise of supremacy.
May I?
There's no permanent interest.
Exactly where I wanted to go. When you talk about interest is one thing, but you need to understand. Let us use school analogy. When you are a regular student, there is a level of respect and there is a way you address teachers. But when you become a school prefect, you take on more authority and you expect to be able to exercise that authority appropriately. Now, coming in as a copper, that's another level of authority now. You can't be, even if it's a copper that just graduated, you can't expect a copper to still take the same level of instructions. The copper expects to be allowed to exercise a certain level of freedom. And so if after taking position, your principal continues to treat you like, you are still at the level you were before, there is bound to be friction. So interest aside, sometimes the fact that people do not know when to, how to respect somebody when they move through the ranks. you continue to treat them as if they are still where you met them. All this is also part of what contributed to these issues because it's not possible. If he wants to perform in his position, so he cannot continue being a yes-sir person to the principal if it's going to affect his own performance. And yeah, interest comes in, but then it's also about performance. Everybody wants to show that they are working in their capacity. And so if all you want me to do is to make you look like you are working without actually doing anything, it's not in my best interest. So that is definitely going to cause friction. There are 1,001 ways to look at this thing, but the issue of ex-accountant generals and their principal, I feel it's always about them still trying to control these individuals as if they've not moved up in the ranks.
Thank you, Tolu. Yes, Ayole, it appears you wanted to say something before Tolu cut in.
No. I only said there's no permanent interest when it comes to politics. You know, everybody we want to, yes, because and then you said something. You said Wike must have maybe consulted one or two.
Yeah, he might have done his groundwork before resolving on Fubara. Yes, as the preferred candidate.
And that's what I wanted to comment on. The truth of the matter is, most of these godfathers, they don't consult other party members before they make their decision because of their own personal selfish interest. I could remember, don't let me make use of that example. Okay, let's say, for example, now, let me say something. For example, during a Fashola regime, we all, if we could remember that there was a time Ambode had issues with Fashola. Ambode had issues with Fashola based on loyalty. And at the end of the day, the same Ambode was picked to succeed Fashola, which Fashola did not support Ambode candidacy. But what happened at the end? Ambode was disloyal again. So I believe most of these godfathers, they don't really consult other party members, because if you look at what has been happening in our political scene, you discover that even many party members are not happy for the candidacy of most of the godfathers, for the kind of person they pick to lead the party when it comes to election.
So invariably now, we can conclude that it was the gun kicked by Wike or the cocked by Wike that eventually was shot against him. It was the bullet.
It was based on eye service. It was based on eye service. Maybe Fuba was doing 1 or 2 eye service for Wike then. So you now believe this is the most loyal person. You know, most leaders, they like eye service a lot. That is what they like when it comes to political scene in Nigeria of today. You must be able to go to them one way or the other to even cook up a lie, too much lie against 1 or 2 persons for them to believe that you are loyal to them. They enjoy it a lot. So that's why I believe. So that's why I said in the beginning, Fuba was not 100% loyal to Wike. For them to have had that kind of issues even before a year.
I think to a very large extent, we've learned so many lessons here too. Away from handpicking, which though we could not say, but nevertheless, because of the grip Wike had in Rivers State, he could as well twist anybody for his preferred candidate to have emerged even as the governor. So it's possible too to have said he single-handedly, presented Fubara to them and he ensured that Fubara won the election. And at the same time, also for that issue like you raised to have happened within a year, it's a pointer and it's a signal that the relationship was just founded on frivolities, were founded on deceit, were also founded on sycophancy. So hence it was easier for them to easily, breakout. Akonde, can we? Okay, Kende, can we hear you, please?
Yeah, I just want to chip in this that we should not forget the kind of person Wike is. Even in the party level, Wike wants to be a domineering person. He wants to be the one that makes that determines whatever happens, even in the party level. And this is even what led to Wike and Atiku parting ways together during the election. And this is now what is happening again. I think, like you rightly said, or the convener rightly said, Fubara is the kind of person that takes shit. And maybe he has been taking a lot of insult from Wike over time that has not been accumulated to what is happening now. Because all of us, we are working, we see when our bosses are working, when we are working with our bosses, the way they do, the way they talk. Some of them even talk to us as if we are nobody. And by the time we get to that position, to be in the same level with them, there's a way we react to them that they will get to realize that they have been making a mistake over time with us. So I think it is now a payback time for Wike. He's just lucky that he's a minister at the moment. If he has been in River State, maybe what happened between Kwankwaso and the Ganduje, maybe he won't even be able to enter River State by now. But let's see what happens. God bless Nigeria.
Yes, thank you so much, Mr. Convener. I think now we are 5 minutes past 8, and we've been able to get opinions from our leaders on the genesis and the aftermath of the issue, which eventually led to the crisis and where we are of 27 being suspended and at the seat as we have currently. So over to you, Mr. Convener.
It's 11:06 now. 11:09, sorry.